appreciate the opportunity to talk to you all. Appreciate our partnership with ACC, and this is, I think, our second presentation. Just by way of introduction, my partner Neal Weinrich and then our colleague Carson Modrall will be talking about this topic. Our firm, Berman, Fink, Van Horn, we're a 20-lawyer firm up on the 16th floor here in this building. And we're a full-service law firm. We do transactional work and litigation. We have real strengths in real estate-related litigation, in employment litigation, and real core of our practice, a lot of what we do is litigating non-compete, restrictive covenant, and trade secret issues, and been doing that for a very, very long time. So this topic is near and dear to us. It's one that I think has there's a lot that can be said about it, both in terms of how we got here and what is going on and what we think might happen. And so that's really what we'll be talking about today. And we'll talk about, first of all, how did we get here? And then what does the FTC's proposed rule do? What's the current status of the rule? What's the likelihood that it'll actually be implemented? And then what should employers, and to some extent, what should employees do now? And to jump right in on the how we got here, for those of you who didn't see it in the news, what I refer to as the Jimmy John's debacle. If you're not aware, Jimmy John's, as we all know, they're a sandwich shop, national footprint, and what they were doing was requiring everybody that worked for the company, including the folks just making the sandwiches, to sign non-competes. And they weren't just any non-competes. Those non-competes said that if you worked at any Jimmy John's, then you were prohibited from 2 years from working at any sandwich shop within 3 miles of any Jimmy John's anywhere in the country. To me, there was a great quote from, I think this is Forbes magazine, a Forbes article. Does a quarter pound of roast beef with a provolone cheese on a baguette count as a trade secret? Sandwich chain Jimmy John's appears to think so. I mean, the absurdity of this, in hindsight, seems like, who would do that, right? Your kid lives here in Atlanta, goes to college in, let's say in Chicago, decides to make a little money on the side and works at a Jimmy John's in Chicago. They come back home to Atlanta. They're looking for their job after graduation, and they're working at a Panera, which is within 3 miles of a Jimmy John's. They're violating their non-compete. And it just, the absurdity of it hopefully is obvious to everyone. But Jimmy John's was doing this, and they were requiring people to sign them, and they were enforcing them. They were filing lawsuits against folks who would violate them. And so it made the mainstream news, made the business news, then it made the mainstream news. There was an uproar about it. And to me, this is really the first time there was sort of this national awareness of the prevalence of non-competes. At that point, the New York and the Illinois Attorney General got involved. They brought enforcement actions, and Jimmy John's stopped the practice of requiring people to sign non-competes. But really, to me, that's where you can trace back a lot of the activity that's been going on, because what's happening with the FTC right now, and also in Congress, Neal's going to talk about some of the bills that have been introduced, importantly on a bipartisan basis. That was really the start of it, and there's been a whole bunch of state-level legislation that Carson's going to talk a little bit about. But now, we have the federal government involved. And I think to me, it's not all that surprising. You can look at any area of the law where the government has gotten involved. When there's an abuse by business, an abuse by industry of something, it's not surprising that the government is going to get involved. Now, I do want to take it back a little earlier than 2014, based on our experience here in Georgia. And Kevin Levitas is here. I promised him I'd give him a shout out. Kevin is general counsel at Hill Manufacturing, but Kevin was in the Georgia General Assembly when the Georgia statute, he was one of the sponsors of the bill that in 2008, 2009 ultimately got passed in 2010 and went into effect in 2011, changed the law here. Prior to that time, all of the non-compete law in Georgia was common law. The judges, sort of this whole series of cases that had come up where it made it very difficult for employers to enforce non-competes. If you had the slightest problem with your non-compete, it would be thrown out entirely. The court couldn't blue pencil it or modify it. And there were quite a few companies in Georgia that were frustrated by that, and ultimately the law got changed in 2011. But I had the opportunity to go down and testify with Kevin's study committee. And the vast majority of people that were coming through were in favor of changing the law. And I sort of got this reputation as being opposed to it, and I wasn't opposed to it. I was just asking questions that I thought needed to be asked and needed to be answered before the law got changed, because there really are a whole host of policy issues that are implicated. My biggest concern at the time was that there were some studies that suggested that greater enforcement of non-competes might not be good for economic development within any particular state or region. And so, the questions I was asking were, is this good for Georgia as a whole? It may be good for certain companies that want greater enforcement of non-competes, but it may be bad for economic development. And, really what's happened since that time is those studies that existed back then were fairly rudimentary. I remember laughing. There was one study that compared the growth of that corridor in Massachusetts. I think it's I-78. There were a whole bunch of tech companies back in the 70s, and it was very similar in terms of the tech community to Silicon Valley. And from that point until 2008, 2009, when this bill was being debated, Silicon Valley took off and turned into what we know today, where Massachusetts has a very nice tech community, but it's not Silicon Valley. And there was a study that suggested that the reason for that was that non-competes were liberally enforced in Massachusetts, and that sort of stifled innovation and stifled some of the growth of companies, whereas in California, non-competes were illegal, and that you had this sort of innovation environment that was fostered by the fact that non-competes were unenforceable in California. Now, Kevin's response to that was, well, where would you rather live, in the snow belt of Massachusetts or in sunny Silicon Valley? And there's something to be said for that, right? And really what's interesting to me is all of the economists and academics and all that have been trying to study this issue then and since that time have all concluded that you can never really control for all of the variables that you would need to control for to have a study that would truly tell you whether greater enforcement of non-competes is good economic policy or not, or whether it's economic policy that's going to drive the things that you want to drive. Now, all of that is just by way of background in terms of sort of what happened here in Georgia back in 2011, then the Jimmy John's thing, and then from that point forward, there really was this move nationally to start curtailing the use of non-competes, because I do think that there's a fair argument that Jimmy John's, just being one example, has been an abuse. And so, most of what's been going on in states around the country is reining in the use of non-competes, for example, with low-wage workers. And Carson's going to talk a little bit about that. Other practices, giving people notice, for example, before they accept a position, that they're going to be required to sign a non-compete so that they can make an informed decision as to whether they want to accept that position. I can't tell you how many times, I've gotten calls from someone who has, sold their house in, I keep using Chicago as an example, sold their house in Chicago, moved their family to Atlanta to accept a position here, and they show up on day one and a non-compete is put in front of them. And now they really have no option but to sign it. And so, for example, Massachusetts, where non-competes were liberally enforced for the longest time, a few years ago they did introduce they passed legislation that has changed some of those practices. One of the big things in the Massachusetts statute is that notice requirement, that you've got to give somebody notice as part of the offer. And that's, to me, just good business. That's just a good business practice, not to spring something like a non-compete or any kind of restrictive covenant on somebody on the first day of employment when they're signing up for the health insurance and signing all of these other documents associated with the start of their employment. So taking a look at really what's gone on, our slide here, the one thing I mentioned this before and I want to mention it again is, we've got the Obama and Biden administrations here, but a lot of this continued during the Trump administration. And as Neal's going to talk about, many of the bills that have been introduced into Congress have been introduced on a bipartisan basis. And there really does appear to be bipartisan support for reining in the use of non-competes. So, part of it was after the Jimmy Johns debacle in 2016, the Obama administration, there was a Treasury report that suggested that non-competes were having a negative impact on the economy nationally. There was a White House report that followed that. And essentially what came out of that was a call to action. And what's really interesting to me about what's going on with the FTC is that the call to action in the Obama administration was for states to look at this issue and make their decisions about whether within each state the law should be changed or modified to rein in the abuse that was being perceived with respect to non-competes. There was nothing in that about the federal government getting involved. And that's what we really started to see. So in 2018, the FTC sort of opened the door to changes and was being pushed by the Obama administration and by members of Congress. And then the FTC started holding these workshops, and this is where I'm talking about. This continued during the Trump administration. There were workshops that continued on about whether non-competes were being abused, and if so, how that was impacting worker mobility, how it was impacting compensation, how it was impacting economic development, whether and to what extent it was impacting innovation. But then really this got accelerated with President Biden's campaign and then his administration. In his campaign materials, there was actually reference to banning non-competes. So that's something that he's had on his radar for a while. And then once he was elected, there was an executive order that he issued. Again, what he did was the executive order sort of ordered the FTC to look into whether through its rulemaking it should address this issue. And then, continuing on through 2021, there were additional workshops at the FTC. And, really it was then in January of this year when sort of all of this exploded. But before I get to that, this legislative activity, this regulatory activity that's targeting non-competes is really rapidly evolving, and I think it really is important to keep up with what's going on. Neal's going to talk about the FTC rule and whether it will go into effect, and if it does go into effect, whether it will be challenged. But you really need to be monitoring the developments with this, but also we'll talk later on about some takeaways, things that you can be doing now to be prepared if the rule does go into effect, or as I think perhaps is more likely, that there's actually action in Congress. One of the things with the FTC rule is it is going to be subject to an attack, and I think that with this Supreme Court, there's a very good chance that the court could find it to be beyond the FTC's power to make a rule in this area. But again, there is this bipartisan legislation that's been reintroduced that seems to be getting some traction. But like I said, really things exploded in January of this year. And if you didn't see it, there were really two things. The one that really gets overlooked, one is the proposed rule, and that came a day later. But what happened the day before was that the FTC announced these enforcement actions that it had taken against 3 companies. One of them was a company called Prudential Security. I think it's up in Pennsylvania, maybe. Basically, what Prudential had done was it had low-wage security folks, basically security guards, who were making minimum wage, making hourly wages. They were being required to sign non-competes that prohibited them for 2 years from working within a 100-mile radius of where they worked for Prudential. And Prudential was aggressively suing security guards that left and were violating these non-competes, even after several courts had found them to be unenforceable. And so the FTC brought this enforcement action saying this was anti-competitive behavior. And it's really quite astounding, and I'm going to go through it in a little detail here because basically what the company agreed to and what the company was ordered to do is pretty incredible. First, it was ordered to cease enforcing, threatening to enforce, or imposing non-competes on the relevant workers. That the company had to notify all affected employees that they are no longer bound by the non-compete restrictions, that the companies were banned from communicating to any relevant employee or other employer that the employee is subject to a non-compete. They were required to nullify the non-competes without penalizing the affected employees. They were required to provide a copy of the FTC's complaint and order to current and future officers, directors, and employees of the company who are responsible for hiring and recruiting. And they were required for 10 years to provide a clear and conspicuous notice to any new relevant employees that they could freely accept a job with any person or company, run their own business, or compete with Prudential following their employment. Part of I think what's going on is people are taking a wait-and-see approach with respect to this rule, but you really need to be thinking about this now because the FTC is on the warpath on this issue, and they are looking into companies that are using non-competes in a way that they consider to be anti-competitive. There were a couple of others that were announced at the same time. There were two glass container manufacturers that also were using non-competes for basically their factory workers. Those were for 1 year, but they were for anywhere in the United States. They involved thousands of employees, and again, the FTC was required they required them to enter into a similar order. As I said, what's really interesting to me is the political angle to this. I've been litigating non-competes for more than 30 years, and I can tell you, I never thought in a million years I would hear the President of the United States talk about non-competes in his State of the Union address. I mean, this is not something that I ever thought would happen, so let's take a look if you missed this.
For too long, workers have been getting stiffed, but not anymore. We're beginning to restore the dignity of work. For example, I should have known this, but I didn't until 2 years ago. 30 million workers have to sign non-compete agreements for the jobs they take. 30 million. So a cashier at a burger place can't walk across town and take the same job at another burger place and make a few bucks more. It just changed. But they just changed it because we exposed it. That was part of the deal, guys. Look it up. But not anymore. We're banning those agreements so companies have to compete for workers and pay them what they're worth.
So, the point of that is that, this is becoming and has become a political issue. I do think that, there is, regardless of what happens with the current rule, in my opinion, and I think in the opinion of just about everybody, goes way too far. Just banning non-competes across the board. That would mean that the C-level executives in your companies could not be subject to non-competes. That's fairly absurd. There's serious problems with the way the rule is written with respect to people involved in the sale of a business. So if you don't own more than 25% of the company when you sell a company, when a company is sold, can't be subject to a non-compete. The idea that someone could sell 50% of a company for $500,000 and be subject to a non-compete, yet someone owns 10% of a company that's sold for $200 million, and that person can't be subject to a non-compete, just makes no sense. And so there's all kinds of issues with this proposed rule. But I do think what ultimately is what had already been happening in a lot of states around the country, and what I do think is going to happen, whether it's through the FTC or through action in Congress, is a ban on non-competes for lower wage workers. And one of the things that Carson's going to talk about is there's a patchwork of, who is considered a lower wage worker from state to state, and perhaps there will be some uniformity brought to that. But I think ultimately that's where this is headed. But on the political side, there does seem to be some sort of political lines that are starting to be drawn. The Republican FTC commissioner, I think her name was Wilson, is that right? She just resigned in protest, saying that Lena Khan, who's the chair, is basically has no interest in due process and in sort of doing things in the way that the commission is supposed to do them. Now, I think it's the House Judiciary Committee is going to start holding hearings on this FTC proposed rule and how it came about. And so I do think that it is becoming a political issue. And even though, like I've said, there's been this what appeared to be bipartisan support to at least address the use of non-competes in some fashion, that may start to change, and it may become an issue that is more an issue of Democrats on one side and Republicans on the other, but that's yet to be seen. So with that, I'm going to let Neal talk about what the proposed rule does and whether we really think it will go into effect, and if it does, whether it can be challenged.
Thanks, Ben. I'm going to walk through the rule itself and really kind of talk about what it does, the different mechanics of it, the scope of it, the breadth of it. Obviously, kind of as Ben has alluded to, we don't really know where exactly this is going to land. The FTC's issued a very broad, far-reaching rule. The majority, the three remaining commissioners, appear intent in being aggressive in addressing this issue. The rule itself, invites comments on various aspects of it, the reach of it, which we'll talk about. But my goal here is really to show you kind of what does the rule look like today, and if the rule were to pass in its current form, what would that mean for your company in terms of the non-competes, the non-competes that you use with employees, and then beyond that. And you'll see in the parts that what we're going to cover is, this really reaches kind of beyond just non-competes and employment agreements. There's other kind of areas where companies have contracts that are going to be implicated by this FTC rule, whether that's incentive compensation plan agreements that include kind of non-competes as part of the awards, or stock award agreements that kind of are used similarly, and then even non-disclosure agreements with employees that might not be subject to non-competes. Some of what the FTC's done here is going to create a need for companies to kind of take a look at what they're doing to make sure that they're compliant with this rule. Again, if in fact the rule in its current form goes into effect. So just to dive right in, the FTC, its original enabling act, it authorizes the FTC to address and enforce unfair methods of competition. And for a long time, the FTC did not necessarily use that enabling language to tackle the issue of non-competes. And then kind of as Ben laid out the history of it, in recent times there's been a focus on non-competes, and the kind of the legal basis that the FTC's majority is saying kind of gives it the foundation to address this issue is this idea of that non-competes are an unfair method of competition. And in its rule, it does make that determination. So we've got what the rule says up on the slide, and the FTC's rule says it's an unfair method of competition for an employer to enter into or attempt to enter into a non-compete clause with a worker, to maintain with a worker a non-compete clause, or to represent to the worker that the worker is subject to a non-compete clause where there's no good faith basis for to believe that the worker is subject to an enforceable non-compete. So then the question is, okay, can't have non-competes with a worker. What's a worker? And the FTC's rule defines a worker extremely broadly, covers employees, covers independent contractors, externs, interns, volunteers, apprentices, sole proprietor who provides a third-party service to a client or customer, excludes franchisees, but does include workers who are providing services for a franchisee or franchisor. So it's a very broad definition of worker that it's not defined by wage, by level, by type of information that confidential information or trade secrets that the worker is receiving at the company. It is essentially capturing the entire labor workforce with no exception. So that kind of takes us to what's a kind of a good summary of the rule. And the key thing is the rule in its current form, it prohibits the use of non-competes in employment agreements for all workers at all levels. So as Ben alluded to, that's not just the hourly wage workers, it's not just the sales reps, it's not just the managers, and it's not just the executives below the C-suite, it's up to the C-suite. It's really kind of anybody that is in the labor pool and it is going to be captured by this definition, and this would be a kind of full-on broad-based ban of non-competes. Now the FTC, in its notice of rulemaking and comment, it has sought guidance and specifically sought comments on whether there should be an exception for senior executives, senior leaders of companies who are involved in that kind of high-level strategic decision-making and have exposure to sensitive trade secret information about planned strategies that would be at risk if the senior executive couldn't be subject to a non-compete and was allowed to kind of freely go work for a competitor. So the FTC has indicated that it wants to receive feedback on that issue, but in the current draft that we have, this is a true broad-based ban. The rule also defines non-competes as including de facto non-compete clauses, and we're going to kind of talk about what that means in a bit more, but we all think of a non-compete as what's a non-compete? A non-compete prohibits an employee from accepting employment with a competitor or starting a competing business after the end of employment. The FTC is using also beyond just kind of what we think of as a non-compete, sort of a functional test for what's a non-compete. So does another provision that's not necessarily labeled a non-compete, does it have the effect of prohibiting someone from accepting employment in a competitive capacity? And I'll talk about that a bit more. There's some examples that are provided both in the rule and in the notice of rulemaking that kind of shed more light on that. And I think that's something, important takeaway is kind of, here are some contractual provisions that the FTC is going to look at and might consider a non-compete under this regime. So bans non-compete, defines non-compete broadly, then it requires employers to notify their workers of the prohibition on the use of non-competes and to rescind any existing non-compete provisions in effect. So if this rule were to take effect, your companies are going to have to give notification to employees that are currently subject to non-competes that, hey, your non-compete's no longer in effect. You're free to work for a competitor. There's actually a sample notice that is included within the rule that I've got a slide on that we're going to get to in a little bit. But this is a express requirement of the rule, which frankly I find a little bit kind of tough to wrestle with the concept that shooting out all these notices that that non-competes are being rescinded. And the rule would supersede state law on non-competes. So the FTC's rule would become the law of the land when it comes to enforceability of non-competes. And obviously, other than a handful of states, I think there's 3 states that ban non-competes. California is obviously the most well-known. Oklahoma and North Dakota also ban non-competes. This would essentially become a 50-state ban. So what's a de facto non-compete? We talked about it a little bit, but the language in the rule is it's a provision that has the effect of prohibiting the worker from seeking or accepting employment with a person or operating a business after the conclusion of the worker's employment with the employer. And there's several examples of de facto non-competes that we have. One is a non-disclosure agreement between an employer and a worker that is written so broadly that it effectively prohibits the worker from working in the same field. Now, I'm sure everyone in here has narrowly and properly drafted non-disclosure agreements and non-disclosure covenants that you're using at your companies, but in our practice where we're reviewing restrictive covenant agreements kind of each and every day, it's not a far cry for us to see a non-disclosure covenant that says something like, for 5 years following the end of your employment, you can't use or disclose any information related to the business or affairs of your employer. And that's not limited to confidential information. It arguably captures sort of general industry knowledge, industry experience. Suppose that employee had effectively been at that company for their entire career. What the FTC is saying is that a provision like that, a non-disclosure covenant that is not narrowly tailored to narrowly tailored and reasonably tailored to truly limit disclosure of confidential information, that's going to be scrutinized by the FTC and is going to be treated as a de facto non-compete. So that is something to kind of take away is are our non-disclosure covenants kind of where we want them to be if this FTC rule does take effect and the FTC is going to be looking at these types of provisions with an eye towards does this kind of fall over into being a non-compete? The FTC's comments do make clear, though, that reasonable non-disclosure clauses, customer non-solicits, and employee non-solicits are not going to be prohibited by this rule. Now, kind of what does that mean? If a company has a multi-level marketing business and there's a employee no hire provision that is extremely broad and would effectively kind of prohibit someone from starting a competing business. Could the FTC look at something like that as a non-compete, a de facto non-compete? What about we see a lot of times not just customer non-solicitation clauses that prohibit solicitation, but that also restrict acceptance of business. And in Georgia, some states allow restrictions like that. In Georgia, you can't have a restriction like that unless you have a reasonable territory. But that's the type of provision that, in some circumstances, the FTC is going to look at and potentially say, okay, this is becoming a de facto non-compete because if this employee goes to work for a competitor and sure, while they're restricted from soliciting, but if customers want to follow them and they can't accept that business, FTC might look at that and say, okay, this is something that is going too far and is effectively prohibiting the employee from competing. So another type of provision that is identified as a de facto non-compete or potentially a de facto non-compete is a training repayment provision where the required reimbursement payment is not reasonably related to the cost the employer incurred for training the worker. That's something that we occasionally see in our practice is when companies are making employees sign an agreement that if you leave, you'll have to reimburse us this portion of your salary kind of as compensation for the training and investment that we made in you. And unless the provision is tied to hard costs, we sent you to this 2-week training session in Charlotte when you joined the company, and we had these hard out-of-pocket costs, and if you leave within 2 years, you have to repay those costs. Something like that, it looks like is going to be compliant with the FTC rule. Something that is not directly tied to costs, it looks like is going to be potentially considered a de facto non-compete. And then another example that the FTC mentions in its notice of rulemaking is disproportionately high liquidated damages provisions. We see that often where a contract might allow competition, but only if the employee pays a certain $100,000 or $150,000 to buy out the restriction, or if we see it a lot in the with accountants, where if accountants there'll be a provision where if customers follow you and you accept their business, you have to pay 150% of the trailing 12 months revenue on that customer's business. And that's obviously a type of provision that is going to have the effect of deterring, and someone's going to have pause about, am I going to leave if my customers follow me and I'm going to have a fight about this obligation, or I'm going to have to comply with this obligation and pay. That's another provision that the FTC is going to take a look at. Sure. And I just realized we have a microphone that we're going to pass around when folks have questions for purposes of recording.
Publicly traded companies often have restricted stock grants for highly compensated employees, and those usually include non-compete agreements, and one of the consequences of violation is forfeiture of the stock. Is that something that's covered by that last bullet?
It's a great question, and it probably is. I mean, when I look at the rule and I look at what they're trying to do here, I don't see any way how the FTC doesn't look at provisions like that and conclude that you can't use the non-competes and you can't enforce the forfeiture of stock awards for a violation of the non-compete. Because I think that forfeiture provision kind of fits within this idea of being a provision that has the effect of prohibiting someone from leaving and competing. And you kind of hit the nail on the head. I think that's there's probably many of the companies in the room use agreements like that, and if this rule were to go into effect, companies are going to really have to rethink, okay, how are we going to deal with these kinds of arrangements and other arrangements where you're incentivizing employees and kind of getting non-competes in return for kind of whatever incentive is being granted.
In my practice, typically, non-compete comes up from HR as in-house counsel, and a lot of companies use the leverage their operations by having vendors and consultants come in, and so there'd be like the two ends of the spectrum would be the high-end consultant. When the consulting agreement says you can't solicit, the consultant's employees, and the employee for the consultant probably says you can't go work for one of the clients. And so on the one end, this probably has intellectual property and trade secrets and all kinds of stuff involved. But the other end, you've got maybe a temporary staffing operation with clerical help saying the same thing, both in the temp contract and trying to tie their employees' hands. You would think that on one end there makes sense to not allow you to hire them, but on the other end it's like the Jimmy Johns.
Yeah, it's a great question, and I think one thing that's probably unclear from the rule is the kind of the B2B contract, right, between the staffing provider or the IT staffing company and the client. If there's a restriction in that agreement where client is agreeing not to hire, that's not an agreement with a worker. That agreement could have the indirect impact on workers, but I think that under the current rule, under the rule as drafted, I'm not sure that it reaches that far to capture an agreement between between two companies like that. Obviously, Ben, weigh in if you disagree.
Yeah, I don't think it's really hard to say how this rule will impact that situation at this juncture, right? This is a proposed rule. We don't have any case law yet. We don't have any interpretation of it. I do think you have to be really careful, and I know you're not in the staffing business, but those in the staffing business, the Department of Justice has been real active on these no-poach agreements and things of that nature, and that was a lot of the precursor to some of what's going on now. And those kinds of agreements that say that the company can't hire the temp employee, those have been under scrutiny as well.
And I think it sort of illustrates what I think is a flaw or something that's just not well thought out with a rule like this is, companies that, an IT staffing firm, a placement firm, without, their business is kind of placing those employees. So if those employees are sort of kind of free to do what they want without restriction, does that destroy a business model? And I think it's something that I don't know that the FTC is particularly thought out. Got a question back there.
Hi, yeah, I actually want to make a comment, and if you're going to get to it later, my apologies. One of the things I thought about, so let's assume there's going to be like a new world where non-competes are going to be scrutinized and just either be used less or completely banned. You can still, in your exit interviews with employees, reinforce a couple of things about your intellectual property, trade secrets, and it doesn't prohibit misappropriation of trade secret cases. It might make you all a little bit busier on the back end. But I don't see anything thus far that says if you have a legitimate misappropriation of trade secret action that you are prohibited from bringing it post-employee moving. So that was my comment.
Yeah, Nicole, it's a great point, and that's part of the sort of inherent tension here is, it was just a few years ago that the Defend Trade Secrets Act, the federal, where trade secret law became federal, and the reason was that so much of our economy is caught up in technology and intangible assets, that there was a concern, and a legitimate concern, that companies were really vulnerable to having that taken. And so the Federal Defend Trade Secrets Act arose out of that concern. And I think one of the things here on the policy side that is really being debated and discussed is that there's a very good argument that the best way to protect a trade secret is to have a non-compete that prohibits somebody from even going to a competitor in the first instance, so you don't have to worry about them taking or using your trade secret in a competitive manner, right? So that's one of the arguments in favor of enforcement of non-competes, particularly for people who have access to trade secrets or highly confidential information. And so I don't think there's going to be anything in this rule or in anything that happens at the federal level that is going to diminish companies' abilities to protect their trade secrets and their confidential information, except to the extent that a non-compete could be the first line of defense in making sure that doesn't happen. And so that's, I think, a big part of what, and a lot of the comments, if you look at the comments that have been submitted to the FTC so far, because right now they're in the comment period, a lot of it has to do with the impact of the protection of trade secrets that this rule would have, and whether this rule makes sense on a blanket basis, again, as opposed to something more limited for folks who don't have access to trade secrets. I mean, there are a lot of really good, legitimate business interests that can and should be protected by non-competes. Trade secrets, customer relationships, potentially employee relationships, all of those things, there are legitimate reasons for them. It's just, and that's where I think that ultimately where I hope this ends up is it's at the lower end where those justifications really don't typically exist.
I haven't heard any mention of B2B contracts, like whether a non-compete in a customer contract, for example, would be covered by the rule. And I would think not, because it's a freely negotiated clause. But I wanted you to confirm that. And the second thing is kind of on the line of what Ben was talking earlier, and also in the context of employment placement. So we occasionally will hire a placement agency to hire employees for us for a particular project. And we're a fintech company, technology is sensitive, right? So, I mean, and then we would negotiate clauses like after leaving our project, the people who you assign to us cannot be assigned to a competitor, which is legitimately a business reason, right, to protect intellectual property. But this is a freely negotiated B2B contract that between our company and a placement agency. So I'm just curious as to how that it really is, I guess, is a comment, because we know it's a proposed rule, we don't know what's going to come out, we don't know how it's going to be enforced, but something interesting to keep an eye on.
Yeah, I think it's a great point. I think the agreement for the individual under this rule would not be enforceable. Right now, would you still be allowed to have a claim against the agency because their person left and went to a competitor? I don't know, and that's an open question. For the individual, that would not be enforceable. I don't know where this would lead on that question for your claim against that agency for allowing someone or placing someone with a competitor. It's unclear to me. I think, Neal, I don't know if you have any thoughts, but the FTC would take the position that that's the same thing, and that would not be permissible.
Yeah, I think it'd be, FTC's being aggressive, and I think it's probably fair to assume that the FTC would sort of frown upon a B2B contract like that. That said, I don't think this rule would reach that the way it's drafted, because it's not a non-compete with a worker. It's a company-to-company agreement where the obligation is on the placement company not to place them into a competitive project after. I mean, one, I think it'd be good to be having that individual sign a reasonable and enforceable non-disclosure covenant of their own, in addition to the company on the other side taking on that obligation and agreeing that its employees or contractors are going to as well. If the non-disclosure covenant is reasonably drafted and reasonably tailored, I don't necessarily think it's a problem under this proposed rule, but I also don't know that if that non-disclosure covenant, if you tried to use it as a non-compete and said, this individual worked for us on this project for 18 months, he signed a non-disclosure covenant, and there's no way he can go work on this competing project for after us, or work on a project for a competitor after.
But he can be liable for disclosing stuff to the other competitor when the bell's already rung, I guess.
Yeah.
I'm not trying to derail your presentation. I know we're not in the Q&A session yet, but my question does dovetail here. So we're talking about B2B. What about independent contractors, right? You go through the steps to determine if someone's an independent contractor or a de facto employee. But if they are found to be an independent contractor, even though they're an individual person, do we think these rules are going to affect an independent contractor who's working very similarly to an employee?
Yeah, worker is defined broadly and expressly encompasses independent contractor.
Yeah, and I would caution you, though, regardless of this rule, that if you're asking an independent contractor to sign a non-compete, I think the Department of Labor in many states, including at the federal level, has taken the position that's antithetical to someone being an independent contractor, right? So you got to be really careful with that, regardless of whether this rule goes into effect.
That could create a de facto employee.
Exactly. Yeah.
So I'll talk real quick about the rescission requirements, just give you an idea of what this is going to look like if it goes into effect. Employers would have to rescind their non-competes by the compliance date, give notice to employees that the non-compete's no longer in effect. It has to be an individualized communication. It kind of can't be a mass email, mass letter. Has to be on paper or in digital format. It can't be a company-wide meeting or a company-wide Zoom where it's, hey, don't worry about non-competes anymore, they're gone. It's got to be formalized. Has to be given to both current and former employees. So if someone left the company 9 months ago, they're still subject to a 24-month non-compete. The way the rule is drafted is the companies would be obligated to formally notify that former employee that, hey, your non-compete's no longer in effect. This is the sample notice that the FTC includes in its rule. It's kind of mind-blowing to me that the idea that a company would send out a letter that says, hey, I'm notifying you that there's this new rule, your non-compete's no longer in effect, you can accept a job with any company, any person, even if they compete with us. You could start your own business, even if it's competitive. You may compete at any time following the end of your employment. I don't know if anyone else kind of feels this way, but the idea of sending communications out like that is shocking. But so talk about exceptions. Ben alluded to this, that kind of the most important and most significant exception, although it ultimately is not a probably not an adequate exception to address the issue, is this sale of business exception. But it only applies to folks that own a 25% interest. So, as Ben alluded to, if you've got 5 owners of a company and each own 20%, and that company blossoms into $1 billion company where each of those 20% owners is taking home $200 million, none of those folks can be subject to a non-compete. And this is something where I think you'll see a lot of substantive comments on this issue and the potential challenges it created. I've read a lot of interesting articles about how the rule itself, but particularly this piece of it, could impact the deal market, right? Are firms going to be prepared to acquire business at this price if the founders or the owners or whoever's still involved with the business can't be subject to non-competes? It's possible this rule could have the impact of kind of devaluing companies or just impacting the deal market that way. Another exception, there are industries to which Section 5 of the FTC Act does not apply. Banks, federal credit unions, savings and loan institutions, common carriers, air carriers and foreign air carriers, persons and businesses subject to the Packers and Stockyards Act. I had to look that up. That's companies engaged in the business of marketing, livestock, meat, and poultry. So that there are some industries that are not subject to the FTC's auspices that seemingly won't be subject to the rule. I mean, interesting questions. Banks these days obviously have all sorts of different lines of business kind of underneath the parent umbrella of a bank. Does the insurance brokerage that sits as a subsidiary under a parent bank, is the rule apply to them? I would assume the FTC might take the position yes, but that's something that we would all need to kind of figure out and explore. The other exception that I've got up here is nonprofit businesses. The FTC's authority only reaches for-profit businesses, and it raises some interesting questions. Obviously, healthcare systems, hospitals, there's other organizations where non-competes are used prevalently that operate as nonprofits. And then you kind of have questions about, okay, if a nonprofit company has a for-profit subsidiary or a nonprofit company gets into a for-profit joint venture with a for-profit company, when can non-competes be used? When can't they be used? I don't necessarily have answers to these questions sitting here today, but there's obviously a lot of interesting issues to think about, some of which may or may not apply to your business, but there's some interesting questions about kind of where is the FTC's jurisdiction begin and end. I'm going to kind of quickly talk about current status of the rule, how likely it is to take effect. We've got kind of a timeline of where things are with the rule. It was announced in early January, formally publicized in mid-January. There's a 60-day notice and comment period. There's been a request for an extension, a 60-day extension. Unclear if that's going to be granted. In the meantime, the FTC's gotten over almost 12,000 comments. Probably by the time that when Carson finalized this presentation, it was 11,923. I bet by now it's 12,000. They're just kind of coming in right and left. Some of those are substantive comments from businesses or trade organizations. A lot of those are comments from employees that have had negative experience with non-competes, but the FTC's promised that it's going to look at each and every comment, which could have an impact on kind of when do we get to the finish line here. So after the notice and comment period ends, FTC is going to look at it. It could obviously finalize the rule in its current form, issue a revised proposed rule. Because of the scope of this rule from an economic standpoint, it's sort of undisputed that this will have billions, hundreds of billions of dollars of impact on the economy. Kind of whether you look at that from impact on wages or sort of impact on commerce. The FTC's notice of rulemaking kind of goes through the different ways in which this is going to impact the economy and the labor workforce. But given the magnitude of it, it's subject to review by this Office of Information and Regulatory Affairs. Then the final rule gets published to the Federal Register. Congress has an opportunity to review and could veto the rule. And then once the rule takes effect, employers have 180 days to come into compliance. And we've alluded to the question of, the question is, can the FTC actually do this? And that's a big question. There's a lot of people out there that think this is well beyond the FTC's authority. There's a few different reasons for that. One is it's unclear in the first place if the original enabling act that gives the FTC enforcement authority over unfair methods of competition, it's not clear that it gives the FTC rulemaking authority. So sort of a threshold starting point of can they issue rules when it comes to non-competes. Another area of challenge is this major questions doctrine. That's there was a Supreme Court case a couple of years ago where a EPA regulation, a Clean Air Act regulation, was struck down, and essentially what the Supreme Court said is when you've got an issue of major political significance, major economic significance, and where kind of historically kind of the states have dealt with the issue, then the agency doesn't have the authority unless Congress has clearly said so. And there's a good argument kind of based on the FTC's enabling legislation that Congress didn't go far enough in saying, FTC, you can regulate in the area of non-competes. And then there's the sort of this broader non-delegation doctrine that's sort of another constitutional theory that kind of questions whether this is something that belongs to Congress, right? Can Congress actually pass its legislative duties onto the executive branch for an agency to handle? So the bottom line is, I'm sure everybody knows we're in a judicial climate with a solid conservative Supreme Court majority where that majority is by and large kind of hostile to the administrative state, and it's fairly likely that it's going to be kind of tough sledding for the the FTC to sustain and defend its authority to issue this rule in the face of kind of the current judicial climate we're in. So lastly, I'm going to talk about the federal legislative activity, the bills that Ben has mentioned that are currently before Congress. There's been two bipartisan bills that have been reintroduced in this session. There have been, over the last few sessions of Congress, different attempts to legislate regarding non-competes. Nothing's been passed, and these bills are both ones that have been reintroduced. One is the Workforce Mobility Act. It actually goes quite far. It's pretty comparable to what the FTC does in terms of being a complete ban on non-competes in the employment context with limited exceptions for sale of business and kind of partnership separations. The second act that has been introduced, this is one that's Marco Rubio and I forget the colleague from the other side of the aisle that has jointly introduced it with him, but he's introduced it in past sessions. It's the Freedom to Compete Act, and this takes a more narrow approach. It's more targeted at the abuse of low-wage workers. It would prohibit employers from entering into or enforcing non-competes with a non-exempt employee under the Fair Labor Standards Act. So obviously a much more lean approach and not the complete employment ban. So with that, I'm going to turn it over to Carson to talk about what's going on at the state level.
Hi. So as Ben mentioned earlier, there's been a lot of efforts over the course of the past decade or so to narrow non-competes, to make them more targeted and reduce the capacity for abuse of non-competes. And one of those things that is in effect is similar to what Congress is going for with the Freedom to Compete Act in narrowing who is subject to a non-compete in terms of what types of employees. Here is an example. There's at least these 10 states that have utilized wage threshold, as you can see, and as Ben mentioned earlier, it's a bit of a patchwork where you've got some it's based on your salary, some it's based on whether you're salaried or employed or hourly employed, some it's based on whether you are an exempt or non-exempt employee under the FLSA. In Virginia, it's if you're under the average weekly wage in Virginia, and so that can also change as the economy in Virginia changes. And makes things, patchworky. A couple other things that are going on, is enforceability of a non-compete triggered by the cause of termination in New York. For example, if you are terminated without cause, then your non-compete is unenforceable against you. And there are a few other states that do something similar where if you're involuntarily terminated, that can have it can be a determining factor in whether your non-compete is enforceable against you. Those states are New York, Washington, Maryland, Massachusetts, Montana, and Nevada. There's also some notice requirements. There's also a handful of states that require advance notice of a non-compete provision, either before you're hired or if you are a current employee, if they are seeking to enforce a non-compete against you or get you into a non-compete, you have to give them notice before they're able to sign it. And the amount of notice varies. It can be up to 14 days. It can just be before you're hired. It can be before it goes into effect. Those notice requirements can be enforced with fines or with a threat of voiding the non-compete if you don't comply with those notice requirements. The purpose of that is to even the bargaining power a little bit between the worker and between the employer. And additionally, several states have set up kind of this limited effective form selection clauses. So you can't just say, oh, well, we're going to use the law for this state, which doesn't have these certain limitations on enforceability. A lot of times states say you have to use our state. And so, yeah, that's what's going on at the state level. And it's important to keep in mind that these are in effect regardless of what happens with the non-compete rule.
Thanks, Carson. So what we want to talk last is, what now? I think there's a couple of things we can talk about, recommendations, but I think there's a few things I want to point out. Neal mentioned this this exception. Nonprofits are not within the jurisdiction of the FTC. And so it raises an interesting question, right? If you've got Emory University, medical system is a nonprofit, and therefore it can continue to use non-competes because the FTC can't regulate Emory University. And then you've got a hospital down the street that's a for-profit hospital that is governed by the FTC and can't use non-competes. You're going to have sort of this unlevel playing field. And it's actually existed for years with California, for example, having non-competes being illegal. and them mostly being allowed in the rest of the country. I'm hearing from my colleagues and from companies out in California that they're actually in favor of this rule because it'll level the playing field for them. They can't use non-competes with their employees, so their folks get hired away all the time, yet many of the people they want to hire from other parts of the country have non-competes and can't come work for them in California. So there are all of these sort of issues about how the rule would impact businesses. I do want to mention, one thing interesting about the Georgia statute is that, the Georgia statute was designed and I think intended to limit the use of non-competes really to higher level employees. Now, unfortunately, it hasn't played out that way. Non-competes in Georgia have been enforced against hairdressers, against backhoe operators, against cake decorators. But I think, the Georgia statute was a little bit ahead of its time in that regard in attempting to build into the statute limits on who could be subject to them. So, for now, in terms of things to be thinking about, you need to take a look at your company's agreements, especially if you have lower wage folks that are subject to non-competes or even other restrictive covenants that, perhaps under this definition would be considered by the FTC to be de facto non-competes. Because like I said, these enforcement actions that the FTC is engaged in are separate and apart from whether this rule goes into effect. And I think the FTC is going to continue to be aggressive in looking for opportunities to bring these enforcement actions and bring these issues to light and make companies examples of that are using non-competes in a way that they view as anti-competitive. Reevaluate your non-disclosure agreements. We did have a lot of discussion and a lot of questions about how this will impact confidentiality provisions, trade secrets. But as Neal mentioned, I can't tell you how many agreements we see that just say like everything in the world is confidential. And a lot of it is just sloppy drafting. It's not the company intentionally trying to say that everything an employee becomes exposed to is confidential. It's just that whoever drafted that agreement sort of cut and pasted from somewhere and didn't really think about what is it in our company that is confidential, what is the secret sauce, what are the things we really don't want people to use or disclose if they leave, and specifically identify those. And most importantly, limit it to things that are actually confidential. Can't tell you how many times I see an agreement that prohibits someone from disclosing information that is either in the public domain or it's known in the industry or it's known to customers, things of that nature where it's really not anything that's confidential yet it's covered by your agreement. And then the other is, looking at your other covenants, because there is this concern about what the FTC would be considered a de facto non-compete. But the reality is that with a very strong and appropriately worded non-disclosure agreement, really good customer non-solicit provisions, employee non-recruitment covenants, and things of that nature, you can generally protect most of the things that you want to protect in your business. I often, when we're asked to draft restrictive covenant agreements for our clients, I really want to sit down and drill down with the client and understand their business, and most importantly, understand what is it they're really trying to protect. Do you really need a non-compete, or are the other covenants sufficient? As I said earlier, sometimes the idea that having the non-compete will be the best deterrent against your trade secrets or your confidential information inadvertently or intentionally going to a competitor, there's a rationale for that, but that's not the case for every employee, that's not the case for every business. Look at what you're doing to protect your trade secrets and your confidential information. Do you have a really robust plan and policy in place to make sure that information that really is a trade secret within your business is identified as such, that the people who have access to it are limited? I can't tell you how many times when I'm on the defense side of one of these cases and someone's claiming that something's a trade secret, and I can go into court and say, Judge, they say this is a trade secret, but there's every employee in the company, thousands of employees, every employee has access to this. That can't be the case that that's actually a trade secret. The quintessential trade secret we all talk about is the Coke formula, right? You don't have to lock everything down like the Coke formula is locked down, but you got to have reasonable efforts to maintain the secrecy of the information to be able to demonstrate it's really confidential or a trade secret. And one of the ways to do that is identify that information, make sure that it is not available to everybody in the company, make sure it's identified as a trade secret, make sure you have reasonable measures in place to protect it. And then, we've talked about some of the other contracts and transactions that this rule could impact, and start thinking about those. There were some great questions about would it apply in this situation or in that situation, and I think you really have to look at your business and think about where are there agreements that are like non-competes that may exist in your agreements with vendors and with others that you work with, to see what it is that you need to do to either figure out whether those agreements will still be enforceable if the rule goes into effect, or whether you can modify them now in anticipation of that possibility. And so I usually like to end with this one. I find it kind of humorous that we as lawyers, our ethics rules prohibit us from entering into non-competes, right? You can't have a non-compete as a lawyer or a law firm. And then the rationale for that is that the public should have the absolute right to choose their lawyer. But what's funny to me about states like Georgia and many other states is that non-competes are perfectly enforceable against physicians and other healthcare providers. So while the public has the absolute right to choose their lawyer, they don't have the absolute right to choose their doctor, and I find that kind of humorous. But I think that is another area, quite frankly, we've seen in some states, and I think that's another area where we'll continue to see more and more legislation, which is addressing specific industries like the healthcare industry and saying that non-competes should not be enforceable in those industries or in certain contexts. So I think we're just about at 1:30 and want to get everybody out on time. I don't know if we have time for any more questions, but if not, Neal and Carson and I are happy to stick around and answer any questions that you've got one-on-one.